The second half of June is supposed to deliver the big Supreme Court decisions, but we're still waiting for the most highly anticipated cases to be announced. What gives? Supreme Court reporter Bob Barnes is back from the court and is here to fill us in. Good to see you, Bob.
Hi.
The three big cases, of course, the two same-sex marriage cases, an affirmative action case, and a Voting Rights Act case.
Yes,
Do we make anything out of not hearing on all three of those? Does that tell us anything about what the decisions may be?
Well, I think there's clearly something going on with this affirmative action case from the University of Texas. That has to do with whether or not a university may consider an applicant's race in making decisions about admittance. The universities say that they need that in order to sort of create a well-rounded student body. The court heard that case argued in October, still have not come to a decision, still has not announced a decision. There's clearly something going on there. We don't know exactly what.
And you've been writing about how we might be able to deduce at least who's writing the decisions based on who's already written some decisions in the different sittings.
That's
and
right.
Justice Kennedy has not yet written a decision in that sitting where that case was heard, so it suggests he might write the decision. And if he were to, what would we know about his jurisprudence to suggest how he might rule?
Well, what we know is that he has never ruled for an affirmative action program. On the other hand, he has been alone among the conservatives in holding out for the fact that there might be the use, an important use for race in some cases. So on the one hand, he's never really seen a race-conscious case that he likes. On the other hand, he doesn't really want to rule out the use of race in all circumstances.
There's this big Voting Rights Act case, and there's only two justices who haven't written from that sitting, and
That's
they're both
right.
conservative.
That's right. I call this Supreme Court bingo.
Yes, it's a fun game.
You can look at where the sittings, they divide their oral arguments into 7 sittings, and then you see who has written an opinion, because they almost all write one, at least, from those sittings. And so in that case, Justice Scalia and Chief Justice Roberts have not written. So it seems pretty clear that one of them would be writing that case. And that's about Section 5 of the Voting Rights Act, which requires some states and jurisdictions, mostly in the South, pre-submit any changes they would make in their election laws so that the federal government can decide whether or not that would hurt minorities.
So if a conservative, one of those two justices, is going to write the decision, it would suggest they're going to say, hey, enough, I think these states can make their own decisions at this
They've
point?
both been very critical of Section 5, Justice Roberts particularly. He wrote the last decision about the Voting Rights Act, and he said that the court had real concerns about whether this law, which was first enacted in 1965, is still relevant in modern times. And so if he's writing it, it's probably not terribly good for those who think the law is still necessary.
And then, of course, probably the biggest two cases of the term, the two same-sex marriage cases. You didn't mention this in the article specifically, but I note that Chief Justice Roberts hasn't written a case from that sitting. He has given himself, of course, he gets to choose, assuming he's in the majority, who writes the decision. So I wonder if there's maybe a thought he might be saving that big case, those two big cases, for himself.
Well, that's a little harder to know at this point. I mean, Justice Kennedy is the one that everyone thinks is sort of the linchpin in that decision, or at least in one of those decisions. It could be that one of them writes one writes the other. They don't have to both be written by the same justice, and they bring up very different issues. One is about the Federal Defense of Marriage Act, which withholds federal benefits from same-sex couples who are legally married in the states where they reside. And the other one is about California's Proposition 8, which was passed by the voters in California in 2008 to prohibit same-sex marriage, but has been struck down by the courts that have looked at it.
And finally, explain to us what happened with the biggest decision we did get today, which was about Arizona's voter registration laws.
Well, what the issue there was, the federal government passed a law called the motor voter registration, as you might remember, which is to simplify voter registration across the country. And it requires that someone who is registering to vote sign an oath that they are a citizen. Arizona wanted to go further than that. Arizona wanted a proof of citizenship, that whoever was applying had to provide some sort of documentation that they were a citizen. The court ruled 7-2 today that Arizona couldn't do that, that federal law is supreme in that area, and that the only way that that could happen is if the Congress and the federal government wanted to include such a requirement.
Okay. We know we will speak at least a couple more times as we finally get decisions on these cases.
Yeah, it's a big close coming up.
It is. Good to see you, Bob. That's it for us for tonight. We will fold things up. Hope to see you back here tomorrow.